For years, millions believed the same story, that after Michael Jackson died, two men stepped into chaos, mountains of debt, a shattered reputation, a legacy on the brink of collapse, and built something extraordinary, that they saved Michael Jackson's name when almost no one else could. The headlines called it a miracle, the courts called it exceptional service, the world called it salvation, but Michael Jackson's own daughter called it something else entirely. She called it a slush fund, and in May 2026, a judge agreed with her. When Michael Jackson died on June 25, 2009, the grief was immediate and global, but behind the candlelight vigils and the radio stations playing nothing but Thriller and Billie Jean, a financial catastrophe was quietly unfolding inside the probate courts of Los Angeles County. According to court filings made public in the years that followed, Michael Jackson left behind more than $500 million in debt when he died. His Neverland Ranch had been in foreclosure proceedings. His spending, even in his final years, had been extraordinary. The estate that bore his name was, in the clinical language of California probate law, teetering on the brink of bankruptcy. Into that crisis stepped two men. John Branca, a music industry attorney who had represented Michael Jackson on and off since the 1980s. He had helped negotiate the purchase of the ATV music catalog, the deal that eventually gave Michael Jackson co-ownership of the Beatles' song rights. He was, by almost any measure, one of the most powerful entertainment lawyers in Hollywood. John McClain, a music executive, an A&R veteran who had worked with Janet Jackson and Aaliyah. He had known Michael personally for decades. Together, Branca and McClain were named co-executors of Michael Jackson's estate. And over the next 17 years, the story they told, the story the world accepted, was a story of triumph. They negotiated the sale of Michael's stake in Sony ATV Music Publishing for over $750 million. They greenlit MJ the Musical, which became a Broadway phenomenon. They developed a catalog of posthumous releases. They commissioned a major Hollywood biopic. And by 2024, what had once been a debt-ridden estate was now conservatively valued at $2 billion. The press celebrated them. Industry insiders praised them. Even the courts, year after year, signed off on their accounts with language that bordered on reverence, praising their exceptional services and calling the estate's transformation nothing short of remarkable. The narrative was clean. The narrative was satisfying. The narrative, it turns out, was incomplete. She was 3 years old when her father first held her over a balcony railing in Berlin, and the world gasped. She was 11 when he died. She grew up inside a legal structure she did not choose, a beneficiary of an estate managed by men appointed before she was old enough to understand what an estate was. She received distributions. She received allowances. She received, over the years, an estimated $65 million in benefits from the estate she was heir to. And for a long time, that was supposed to be enough. But Paris Jackson, now in her late 20s, started asking questions. Not easy questions. Not polite ones. She wanted to know where the money was going. She wanted to know what the accounting statements actually said. She wanted to know why, in 2021 alone, the co-executors had reportedly paid themselves more than $10 million, a sum that dwarfed what the actual heirs of Michael Jackson received that year. She wanted to know why certain payments had been made, why certain decisions had been taken without consultation, why the estate that bore her father's name sometimes felt less like a family trust and more like a private corporation run for the benefit of the men managing it. Her legal team filed objections, the estate filed responses, and those responses, obtained by multiple media outlets, gave the public its first real look at how Branca and McClain chose to deal with a beneficiary who dared to ask hard questions. They did not answer her directly. They questioned her motives. They suggested she was being manipulated by her attorneys. They accused her team of staging tabloid press photo ops and strutting into hearings with obvious props. They noted repeatedly, pointedly, that she had already received $65 million and implied that someone who had received that much money had no standing to complain about anything. But Paris Jackson was not complaining about her distributions. She was complaining about transparency. And that distinction matters more than anything else in this story. To understand what Paris Jackson was actually fighting, you need to understand something about the structure of Michael Jackson's estate. It is not a simple trust. It is not a quiet family inheritance managed by a bank somewhere. The Michael Jackson estate is, functionally, a multi-billion-dollar entertainment corporation, one that operates under the oversight of the Los Angeles Probate Court, where every major expenditure, every accounting period, every fee paid to every attorney is supposed to be reviewed and approved by a judge. Supposed to be. In practice, estate cases of this complexity move slowly. Accounting periods can lag years behind real time. Payments made in 2018 might not come before a judge for formal approval until 2025, and in the intervening years, enormous amounts of money can move through an estate without any beneficiary, any heir being given a clear, comprehensible account of where it went. That is precisely what happened with the payments at the center of Paris Jackson's legal challenge. In the second half of 2018, John Branca and John McClain authorized $625,000 in bonus payments to 3 outside law firms that had been working on behalf of the estate. These were not regular billing amounts. These were bonuses, additional payments, above and beyond standard legal fees, paid to reward the firms for work the executors apparently considered exceptional. The problem was simple. Nobody asked the court. Nobody asked the beneficiaries. Nobody filed for advance approval. The payments were made quietly, internally. And then, years later, when the executors filed their accounting for that period and asked the court to retroactively approve those expenses, Paris Jackson objected. She said the payments lacked sufficient explanation. She said the estate had not demonstrated why these bonuses were warranted, what specific work they were compensating, or whether they represented a reasonable use of estate funds. In June 2025, she raised the objection formally, in court, on the record, and that is when things got complicated. But here is a detail that almost never made it into the coverage. John Branca, the man who has managed Michael Jackson's estate for 17 years, the man who transformed it into a $2 billion empire, the man who has been praised by courts and celebrated by the industry, is the same attorney that Michael Jackson fired multiple times while he was still alive. Paris Jackson's legal team made sure the court knew this. In a pre-hearing brief filed in early 2026, her attorneys described Branca by invoking the film A Few Good Men, writing that he had essentially testified he had neither the time nor the inclination to explain himself to his beneficiaries, and would prefer they simply said thank you and went on their way. But the firing detail is not just a rhetorical flourish. It raises a question that the estate's triumphant narrative has never fully answered. If Michael Jackson himself had reservations about John Branca, serious enough to remove him from his affairs more than once, what would Michael Jackson have thought about Branca managing his estate, controlling his image, producing a biopic about his life, and making financial decisions about his children's inheritance for nearly 2 decades after his death? We cannot know. Michael Jackson cannot tell us, and that perhaps is precisely the problem. There is another detail worth sitting with. Paris Jackson and her brothers, the legal heirs of one of the most famous human beings who has ever lived, do not have free access to their father's personal belongings. If they want to access certain items from Michael Jackson's personal estate, childhood memorabilia, personal objects, things a father left behind for his children, they may need to petition a court for permission. This is not a tabloid exaggeration. This is the legal reality of an estate still under probate court supervision, 17 years after the man died. An estate so complex, so tangled in corporate structures and licensing agreements and ongoing litigation that the simplest acts of inheritance require a judge's signature. Let that sit for a moment. In April 2026, the long-anticipated Michael Jackson biopic, simply titled Michael, arrived in theaters, directed by Antoine Fuqua, starring Jaffer Jackson, Michael's real-life nephew in the lead role, produced in part by the estate itself. The film had been years in development. It had faced delays. It had, according to court documents filed by Paris Jackson's legal team, been forced into costly reshoots, reportedly totaling tens of millions of dollars, after a previously undisclosed 1994 legal settlement tied to past allegations surfaced and necessitated significant script revisions. Paris Jackson was not a fan. She called it sugar-coated and dishonest. Based on the script she had reviewed, she stated publicly that she had 0% involvement in the project. She did not attend the Berlin premiere, where her brothers Prince and Biggie did appear. She was, in the language of Hollywood, conspicuously absent. Her legal team went further. They raised formal objections about the estate's management of the biopic, questioning the handling of the reshoots, the accounting of the film's costs, the decision-making process around the script. They argued that the estate had mishandled the situation and that the financial fallout from the production chaos was ultimately a cost being borne by the beneficiaries. The estate's response was withering. Branca and McLean's attorneys accused Paris of having a complete lack of understanding about how the motion picture industry works. They called her objections false and frivolous. They suggested she was more concerned with taking personal shots at John Branca than with any actual financial questions, and then they returned, as they always did, to the $65 million. Paris has already received roughly $65 million in benefits. The March 2026 filing stated, she stands to inherit many hundreds of millions more, just as her father intended. The implication was clear: be grateful, stay quiet. Paris Jackson was not inclined to do either. The ruling came on May 13, 2026. Retired Los Angeles probate judge Mitchell L. Beckloff, who had for many years presided over the Jackson estate case before transitioning to the role of private referee, issued a 23-page ruling. Sided with Paris Jackson. His language was precise and measured, in the way that judicial language often is when courts are doing something significant without wanting to seem dramatic about it. He wrote that the court could not determine that the $625,000 in bonus payments had been just and reasonable based on the information provided by the executors. He disallowed them entirely. $625,000 ordered back to the estate. The executors' legal team acknowledged the ruling and stated they would comply, but they also made sure to quote the judge's earlier, more complimentary language back to the public. The part where he noted the estate had been transformed from one that started out as nothing but debt and substantial obligations into a $2 billion estate, and had praised the executor's exceptional services. It was a careful move, a face-saving move, but it could not change what had just happened. A young woman, a beneficiary, an heir, a daughter, had walked into a courtroom and told a judge that the men managing her father's estate had made financial decisions that lacked adequate explanation and transparency, and the judge had agreed with her. Paris Jackson's spokesperson released a statement. Paris has always been focused on what's best for her family, and this ruling is a massive win for them. After years of delay, the Jackson family will finally get the transparency and accountability measures Paris has fought for. And then came the line that would echo across entertainment media for days. The Jackson estate is supposed to be a prudent, fiscally responsible entity that supports the Jackson family, not a slush fund to help John Branca live out his Hollywood mogul fantasies. Not a slush fund, Hollywood mogul fantasies. It was incendiary language. It was strategic language. And it was in the aftermath of a court ruling that had just validated her concerns, language that no amount of counterstatement could fully diffuse. Here is where we have to pause and be honest about what we know and what we don't. John Branca and John McClane are not villains in a simple story. The financial transformation of Michael Jackson's estate is real. The debt was real. The turnaround was real. Courts have repeatedly praised their management, and those praises were not manufactured. They reflected genuine outcomes. The $65 million Paris Jackson received from the estate is also real, and the estate's argument that without aggressive, sophisticated management, that money would not have existed has genuine merit. But none of that addresses the core question Paris Jackson has been asking for years. The question is not, did the estate make money? The question is, who decided how that money was spent, and why didn't the people who own that money have the right to know? There is a structural problem at the heart of long-running estate cases like this one. When a highly complex estate generates enormous revenue, and when the men managing it are also the men approving payments to law firms that represent the estate, and when accounting periods run years behind real time, and when beneficiaries are expected to trust the process without being given a comprehensible accounting, something is fundamentally broken. It may not be broken because of bad intentions. It may be broken simply because no one was watching closely enough. Paris Jackson watched closely enough. We spend so much time talking about the financial dimensions of this story, the billions, the bonuses, the accounting periods, that it is easy to lose sight of what is actually happening here, A woman in her late 20s is fighting in court for the right to understand where her father's money went. She cannot freely access her father's personal belongings without navigating a legal structure that requires court oversight. She watched a major Hollywood film about her father's life be produced, filmed, and released without her meaningful involvement, a film she described as dishonest. She has spent years being publicly characterized by the men managing her father's estate as someone who doesn't understand the business, who is being manipulated by her lawyers, who is more interested in tabloid attention than in legitimate concerns. And through all of it, she kept filing documents. She kept showing up to hearings. She kept asking the question, not the easy question, not the grateful question, the hard one. In a filing from April 2026, as the legal battles were reaching their peak intensity, Paris Jackson's attorneys wrote something that stripped the case down to its human core. This litigation is painful for Paris. It is a distraction from her own life and her own career. This is not someone who enjoys conflict. This is someone who believes that the institution managing her father's legacy owes her family an honest accounting, and who was willing to spend years in courtrooms to prove it. The May 2026 ruling is a single data point. $625,000 in a $2 billion estate is, in purely numerical terms, a small sum. But legal cases are rarely just about the money. What Beckloff's ruling established, quietly, in 23 pages of judicial language, is that the managers of Michael Jackson's estate cannot simply make financial decisions and expect retroactive approval without adequate explanation. That the beneficiaries of that estate have standing to object, that transparency is not optional. These are principles, and principles, once established in court, tend to compound. There are still open battles ahead. Paris Jackson has raised broader concerns about the estate's delayed fee and accounting practices. The question of what eventually happens to the estate, whether it remains under probate court supervision indefinitely or whether it is distributed and closed, remains unresolved. And the biopic is out. The world has watched it. Whether it tells an honest version of Michael Jackson's story, whether any version of his story can truly be honest, given everything that surrounds it, is a question that will be debated for years. Paris Jackson doesn't think it does. She had 0% involvement. She did not say thank you and go on her way. Here is what we know. Michael Jackson died in 2009, leaving behind a financial catastrophe and 3 children. 2 men were appointed to manage what remained, and they turned it into something extraordinary by almost any financial measure. But the story of what an estate is for, whether it exists to generate maximum financial returns, or to honor the intentions of the person who died, or to serve the actual human beings who will eventually inherit it, that question was never answered in the documents that celebrated the turnaround. Paris Jackson asked it anyway. And in May 2026, sitting in a Los Angeles courtroom, a judge looked at $625,000 in payments that could not be adequately explained and said that is not good enough. It wasn't a revolution, it wasn't a scandal in the conventional sense, but it was a daughter telling a machine, "My father's name is not just a brand, it belongs to people, and those people deserve to know the truth." Whether the machine will listen is still an open question. What is not an open question is this. For 17 years, the story of Michael Jackson's estate was told by the people who ran it. In 2026, for the first time, a court agreed that there was another story worth hearing. The truth is rarely as simple as the headlines make it seem.